Ladies and gentlemen, it is important to state that we are not here to prejudice the guilt of any person who has not been convicted by a court of competent jurisdiction. We are, however, entitled to ask legitimate questions arising from the evidence placed before the court and to demand that the appropriate Ghanaian institutions investigate those matters fully and transparently. The Holy Rain scandal. According to the evidence presented in the United States proceedings, a scheme was developed to bribe not only government officials, but a relative of President John Mahama in order to push a power plant deal through at the height of doom so, when what Ghana was desperately seeking additional electricity generation capacity. One of the emails presented to the jury referred to a Ghanaian official who was awaiting his expected payment as waiting for Holy Rain. There was therefore nothing holy about those payments. If the expression Holy Rain was used to describe money expected by officials involved in the transaction, then what Ghana witnessed was not a rain of blessings, but a rain of corruption. One that threatens to expose the manner in which decisions affecting the national interest may have been compromised for private gain. More disturbingly, the matter has now become an international embarrassment for Ghana because the evidence was not uncovered through a successful domestic prosecution, but through proceedings in the United States. How shameful. The evidence before the United States courts concerned efforts by Goldman Sachs, acting through its United Kingdom subsidiary, to secure a transaction for its client, the Turkish power producer Aksa Energy Üretim AS, to build and operate a power plant in the Republic of Ghana. For the project to proceed, Aksa required an emergency power agreement and the necessary approvals from several Ghanaian institutions and officials, including the Ministry of Power, Cabinet, the Ghana Grid Company Limited, GridCo, and the Public Utilities Regulatory Commission, PURC. The prosecution's case was that improper payments were contemplated or made to individuals connected with the approval process. The evidence presented to the court identifies several categories of Ghanaian officials and persons connected to the transaction. So who are these government and public officials under the then President Mahama administration who were bought? Per the record of the U.S. courts based on which the conviction was made, the government/public officials and close relatives of the president at the time who were involved in the scheme are as follows. The Minister of Power at the time. He was responsible for this execution of the emergency power agreement on the 12th of May 2015. Prosecutors proved that the conspirators discussed paying $1 million to the Minister of Power and $250,000 to his senior advisor. Ghana Official 1, advisor to the minister. The man said to have been waiting for the Holy Rain, chased progress, demanded weekly reports, and was assured of his full support and cooperation. Ghana Official 2, Senior Ministry of Power official on the emergency project team, listed as $10,000 on the ledger. The presidential relative. Very interestingly, if you recall the airbus scandal, there was a relative of the president on the airbus scandal. And on this one too, a relative of the president has been listed. And in all material situations, the common denominator here is President Mahama. In airbus scandal, it was President Mahama. And in respect of the Holy Rain scandal, it's President Mahama. The question is, who is this relative? Ladies and gentlemen, one of the most disturbing aspects of this matter is the payment ledger introduced into evidence before the United States court. The ledger reportedly contains a breakdown of payments allegedly earmarked for various individuals and institutions connected to the transaction. The relevant entries appear at page 14 of the court record. Among the entries are amounts associated with Ghanaian public institutions and persons connected to the approval process. These entries cannot simply be ignored. They raise questions that are capable of objective verification through financial records, institutional records, correspondence, procurement documents, meeting minutes, and other official documentation. The New Patriotic Party therefore believes that the appropriate Ghanaian investigative authorities must obtain and examine complete court records and trace relevant payment, beneficiary, intermediary, and decision connected to the project. It is important for us to place in context the circumstance of Ghana at the time when these payments were made. The timing of these events makes the matter even more troubling. The Ministry of Power was established on 22nd November 2014, and Dr. Kwabena Donkor was appointed minister. At the time, Ghana was experiencing severe and prolonged shortages. The minister publicly committed himself to ending doomsday by the end of 2015, and famously placed his position on the line in relation to that commitment. It was against this backdrop that the transaction under the investigation was being pursued. According to the evidence presented in the United States proceedings, on 20th April 2015, an amount of approximately $500,000 moved from Turkey to Ghana through New York. On 12 May 2015, so let's look at the timelines. Movement of money to Ghana on April 2015, April 20th of April 2015. And then on May 2015, the emergency power agreement with AXA was signed. These days, viewed against the wider evidence, require careful investigation. While questions concerning payments and approvals were unfolding, ordinary Ghanaians were bearing the enormous economic and social cost of doing so. The Institute of Statistical, Social and Economic Research estimated that the cost of doing so in 2014 alone was between approximately 320 million, representing about 2% to 6% of Ghana's GDP. A separate ESA study involving 885 small and medium-sized manufacturing firms reportedly estimated losses of approximately 250 million during the doomsday period. Some 280 firms reportedly ceased operations, with approximately 5,000 jobs lost, while manufacturing contracted by about 2% in 2015. This is the context in which the allegation must be understood. While Ghanaian households struggled with prolonged power outages, business closed, workers lost their jobs, and the economy suffered significant losses, there are allegations that individuals connected to the process were seeking private financial benefits from a transaction intended to address the country's power crisis. That contrast is profoundly disturbing. What is obvious is that what would ordinarily be concealed by the NDC government through the Attorney General's filing of nolle prosequi will be exposed on international plane, where there is no NDC government to prevent prosecution or arrange a charade of prosecution. Hence, the lack of deterrence, which has not only emboldened persons involved in such corrupt practices, but has also led to a pattern of embarrassment on the international plane. This point is very, very important. It's important to the extent that we notice a trend where the government is constantly protecting people who are involved in one corrupt practices or the other and connected to the NDC party through a charade of prosecution or not the filing of nolle prosequi or discontinuance to free them. They then become very emboldened to continue with the corrupt practices. These are persons who are connected with the NDC, but their conducts are constantly exposed on the international plane. And in no time, I'll show you a historical trend of how this has embarrassed Ghana. We therefore believe it is necessary to recall some of these instances, not to suggest that they are legally identical, but to demonstrate why Ghana must strengthen its domestic mechanism for investigating and prosecuting corruption. That requires serious investigation in this latest scandal, a pattern that Ghanaians cannot ignore. Ladies and gentlemen, some may be tempted to dismiss this matter as another episode of partisan political disagreement. We urge Ghanaians to resist that temptation. The issue is larger than partisan politics. We are witnessing a troubling pattern in which allegations of corruption involving Ghanaian transactions have repeatedly come to light through proceedings, investigations, or settlements outside Ghana. In 3 of these cases, the names of President John Mahama or his relative pops up. Gassem Skansen. In proceedings before the Asker and ay3hu district courts in Norway in 2007, litigation involving Skansen International ANS and its former Africa manager brought into public domain evidence concerning alleged payments arrangements involving Ghanaian political and party interests during the 1990s. The court's findings must be distinguished from allegations or evidence that were not adjudged against any particular individuals. Nevertheless, proceedings exposed issues concerning the movement of funds and alleged political payments under NDC 1 and NDC 2 administration. Maybe and Johnson. On 25th September 2009, Maybe and Johnson pleaded guilty before the Southwark Crown Court in London to corruption offences involving Ghana and Jamaica relating to conduct between 1993 and 2001, again under NDC 1 and NDC 2 administration. The company was fined approximately £3.5 million. The Ghanaian transactions concerned contracts for bridges reportedly worth tens of millions of pounds. Amajaro, 2010. The Amajaro matter requires particular caution. Unlike Maybe and Johnson and Airbus matter, Airbus which we shall speak to shortly, there has not been a court judgment establishing criminality against Ghanaian officials in relation to allegations referred to here. What is publicly known is that cocoa buying company by name Amajaro, which had faced restrictions in Ghana following allegations of smuggling, subsequently had those restrictions lifted. And a British cabinet minister reportedly lobbied the Ghanaian government on the company's behalf. This was done through a senior government official who was later alleged to be the vice president at the time, now President John Mahama. In other words, President John Mahama, as vice president, was lobbied by a British cabinet official to get a reprieve for the ban imposed on Amajaro, a UK-based cocoa buying company that was found guilty for smuggling cocoa out of Ghana, as uncovered by investigative journalist Anas and Aremiao Allah Anas. This scandal was revealed by a report in the British media in the year 2010. The Airbus scandal. Crown Court Asavek, 31st January 2020, before Dame Victoria Sharp, the approved deferred prosecution agreement records roughly £5 million in success-based commissions promised or paid to a person the judgment calls Intermediary 5, described as a close relative of a high-ranking elected Ghanaian official over the year 2009 to 2015, who was referred to as Government Official 1. The OSP investigated the matter and confirmed the identity of Government Official 1 as President John Mahama, President John Mahama, His Excellency. The OSP also established that President John Mahama's direct involvement in the deal President John Mahama's direct involvement in the deal involved his biological brother, patient a conflict of interest rules. President John Mahama, the Government Official 1, and his relative were also implicated in this Airbus scandal. The Embraer 190 scandal. According to the former Attorney General and former Special Prosecutor, then as Attorney General was compelled to set up a committee of inquiry to investigate His Excellency President Mahama over his suspicious corrupt conduct in the purchase of the aircraft, including Embraer 190, and hangar for the armed forces. According to him, the committee comprised William Abua, George Amwa, and Brigadier General Alote. Then we now have the Holy Rain, which is the fifth, being the Ashanti Media case, alias the Holy Rain scandal. This time, it is not merely an allegation contained in a newspaper report or a political statement. A United States federal jury has returned a criminal conviction against Ashanti Media following a trial. The underlying evidence concerns alleged payments connected to Ghanaian public officials and a Ghanaian power project. This should compel every responsible Ghanaian institution to take this matter seriously. In view of the seriousness of the matter raised by the United States proceedings and the pattern that has been captured above, the New Patriotic Party makes the following demands. We call for the publicized independent inquiry into the circumstance surrounding the ASCA power project and the allegations of improper payments connected with it. The purpose should not be political vengeance, but one seeking to unravel the truth, accountability, institutional reform, and deterrence. This is extremely necessary because we need to stop this from reoccurring on the international plane. Otherwise, we'll continue to be embarrassed on the international plane. And so it's very, very important we go through this. Through this inquiry, the names and official roles of the persons who handled the ASCA approvals and related processes in 2015 will be exposed. And the extent to which the bribe payments involving the approvals will come to light. The court record reportedly contains payment entries of approximately $120,000, for instance, to PURC. $20,000, for instance, associated with Greatco Engineers. These allegations require immediate investigation. The public inquiry will reveal the identity of the individual described in the United States courts as the presidential relative. This is particularly important because the matter raises questions similar to concerns that arose in the Airbus scandal, where a person described as a close relative of a high-ranking Ghanaian official appeared in the relevant court record. The Ghanaian public deserves to know who was this person. What was the person's relationship with President John Dramani Mahama, His Excellency? What company or entity was the person associated with? What role did the person play in the ASCA transaction? Did the person receive any money? If money was received, how much? For what service or purpose? More importantly, Ghanaians want to know why it is always a relative of President John Dramani Mahama. How his involvement influenced the approval process. The NPP wishes to place on record its lack of confidence in the current Attorney General as far as the handling of this matter is concerned. Since assuming office on the 22nd of January 2025, Dr. Dominic Ayeni, as Attorney General, has been associated or has been keen with the filing of discontinuance or nolle prosequi or abandonment of prosecutions involving persons connected with both the previous government and the current NDC administration. We recall, in particular, the Attorney General's entry of nolle prosequi in matters including the Smith scandal, the Saglemi housing projects case, the Cocoa Board related cases, the Unibank case, among others. These decisions have raised serious questions about accountability, the recovery of public funds, and the extent to which taxpayers may ultimately bear the financial consequences. In particular reference is the Unibank case, which forms part of a wider banking sector cleanup and involved substantial public expenditure. The Attorney General has not only come under criticism for failing to make critical disclosure before Parliament, the Attorney General has failed to make public details of the plea bargain that he purports to have entered into with the accused persons in the matter, thereby fueling concerns about transparency and accountability. Against this background, we do not believe that the Attorney General can command the confidence of the Ghanaian public to independently investigate or prosecute allegations involving officials or politically connected persons of the NDC. The repeated discontinuance of prosecutions involving persons associated with the NDC administration has created a reasonable perception of selective accountability. The Ghanaian people in this circumstance deserve investigations which they can have confidence in. One that is guided not by political affiliation, but by the evidence, the law, and the national interest to avoid or prevent the reoccurrence of such embarrassment on the international plane. Ladies and gentlemen, this is simply not an American case. It may have happened in America, but it is not an American case. It involves an underlying transaction, a transaction that concerned Ghana, The alleged payments were connected to Ghanaian public officials. The approvals required from Ghanaian public institutions. The power project was intended to operate in Ghana. The consequences of any improper conduct were therefore borne by Ghanaians. The minister involved was a Ghanaian minister of state appointed by President John Mahama. The officials associated with the relevant approval processes were Ghanaian public officials appointed by President John Mahama. The institutions whose processes were allegedly compromised were Ghanaian public institutions. It is therefore misleading to characterize this simply as an American matter. It is fundamentally a Ghanaian governance and accountability matter that happened to be uncovered and prosecuted in the United States. In conclusion, the NPP is calling for accountability, not selective accountability, not partisan accountability, but national accountability. We are calling for the truth to be established. We are calling for the evidence to be examined. We are calling for every person who may have participated in wrongdoing to be investigated in accordance with law. We are calling for every innocent person whose name has been brought into public discussion to be given the opportunity to clear his or her name. And where wrongdoing is established, we demand that the law be applied without fear or favor. The time has come to break the cycle. Ghana cannot continue to be a country where allegations of corruption involving Ghanaian public officials are uncovered abroad, while domestic investigations remain inconclusive. We cannot continue to allow the international community to ask questions about Ghana, about Ghanaian corruption, that Ghanaian institutions appear unwilling or unable to answer. The Holy Rain case must therefore become a catalyst for a comprehensive examination of the circumstances surrounding the AXA project, the individuals involved, the payments allegedly made, and the institutional safeguards that failed. The Ghanaian people deserve answers. They deserve accountability. They deserve institutions that protect the public interest rather than private interest. And above all, they deserve a government and public institutions that understand that public office is a trust, not opportunity for private enrichment. Thank you very much. And then the tendency mu nyina ne say ye nyina ye nim scandal bi aba ye friend the Holy Rain scandal eye Ghana ni abrantie bi eye American brochimem ne ho akoto adwam esanse ye se bra Ghana dum so ni gina so a nipa etem penten kwa na mfifire te nipa no saa bre no na yehia power plant na saa power plant no saa bre no enam se na ye ho eyira yenti ye call power plant no through sole source and as a single source na enam so masikatua bi baamu enti America for edo mo nsa aso abrantie ni mu ewa America ene wadi for yedi na sema manadi for yedi na sema ni di for no yen Ghana for so de na yeye if we say nipa a wonti yedi abrantie yasem ama wona di for no ama na di for no eye Ghana for ebinom yese na omo ye ministers ebinom no omo ye public office holders and a krachi etuetu eskama wo mo enu nti na America abochima mu krachi no ne ho ato akọ adwa mu enti enade na ye ya afa ho ye beja ama na kosa akwa anase ebetu ho na mo se ne ebe ya echina ebi nsie de enti a ehu hia se yetu ho na mo ene se Sa animguasie ato Ghana. Edi kan in the year 2007, the Gassen Scansum scandal eba so ewo Norway abrochimem. As abre yesi Scansum for tuitua bribes ema Ghana abemu mpanyifo. Ema sabre no eno so ya asem ewo Norway. Etoso mienu sabre no edikan no na NDC for the wa ban. Ye toso mienu so si ye Mebe and Johnson. Esi wo afe case no ye di no England abrochimem September 2009. Case ne ba so no eno so saa ye se sikatuatua bi aba ma Ghana mpanyifo e ma Ghana anim gu ase ewo inyiresi abrochimem. Ana afi so amajaro eso de ne ho ebeji mu. Enu koda ena eba scandal so bae. Enti abre bia no sansem wi ebeba na akosi wa abrochimem na egu Ghana mpanyifo anim ase na egu Ghana man ho anim ase. Na ewie kire bia na emrantie na ye de omuko gina court no na se nipa ye de omuko gina court no ya na abrochire court no ebua omofo se omatuatua ketasehye omatuatua damude e de ama Ghana mpanyifo. Case we so abre bi ebesi bia no na NDC for ne wa ban nipa omhobo omu nyina nso a ye bobo omudin no ya na omu ye NDC for mpanyifo. Entinei President Mahama bra okọ ahomeje ana eba scandal no ebaye. Enei we die abaye na dimisem sabi enya atesem. De ye kan se sanye animguase na adoso wo Ghana so e wa abrochimem no. Ye sra ban se onti commission of inquiry na yemfa hwehwe asem mu. Sanye ebeye nsa na ho na nipa bia sabi daachi bi ono so peso ye bibi saa no em se onye biu fisasi ya anya kwa na ekoso na essence attorney general ni NDC aban on the any se won afo di bone a na wa file nolly prosecute no waja wo mu ana se omudi bone a asotwe esese ye de wo mukọ court mi ye twe wo maso essence omo ye NDC fo nti onye nti no ahye won kutupa ama saade no kwa na akoso saa eti se ye nyae a sabi eben se wo no batifie na won kye na so obekwa abonten di okodi bone a nipa bi ebebo no ho ana ombekye wo maso na enya asotwe keke asotwe na chi ye animguase a eba ma Ghana man enu nti na ye srese eni ade we wo se yete commission of inquiry the nti esese yete commission of inquiry hwehwem no ebio ene se attorney general owe ni dwumadi a wadie nyina kire se onye na dwen se so obi ye NDC ni a na so ye bone a sabi ode ne bekwa akogina court ama asotwe bi abam mo munim se free so oba abam NDC ni bia ye bone a no a file no le prosecute sabi ebirum kra timi di judges atem no ba fa kwa bi so do ma ko judge na nim na judge no kra ja wo mu ye nyina ye nim na ebirum kra nso di judge atem no mo ba proma se ya ni amo mo police protection national security protection sabi ye sa mo ahemfie papa mpoda enti yanyi ni se o ma ne kwan se onye nhwehwemu a obeye nhwehwemu krojen attorney general no onye na wa anya nhwehwemu krojen nso a animguase a akoso no enu a na besa akoso enti esrew mampanyin se obiente public inquiry, independent inquiry, commission of inquiry na onhwehwa de wemu fi se enye baako pe enye ne baako so a esinie ayeko ayeno ayesa ayenum yanhwe ya dabi Ghana mampanyin nam abrochimemu ana abrochire kuro bi akwakoche no se odeni kogina trial yanhwe ya Ghana minister bi nam abrochimemu na dabi sene esi wo Venezuela enom ne akan ayi aman bi nso no yɛbɛhwɛ na afei ɔman bi ɛkɔ akɔkye Ghana man minister bi say ordinate kɔ stand trial but si yɛyɛ nhwehwɛmu na sɛbe di asotwe fata no yɛde ama no a ɛbɛyɛ nsa na hɔ sɛnea ɛbɛyɛ adaakye ade a ɛkɔ so yi ebi nsi bio ɛno nti na New Patriotic Party ɛnɛ ya friends and trophies chair mu yi a demand said there should be a public inquiry into this matter na die ne hu son no ne hu son die odi fo nso na emra nso ɛde na kwa akogina yi we ni yanu di sema ye de to wadi